Chairman. Thank you, Attorney General Holder, for joining us today.
Morning.
In our meeting today, you've used the term constitutional crisis several times, and I share.
I think about that. Maybe constitutional conflict would be a little better.
Conflict. Okay.
That's making it a little more.
One way or another, your use of that term reflects a concern that I share to make sure that the government is operated within the confines of what the Constitution allows. I, like many of my constituents, have some concerns with regard to how this president and his administration have viewed certain constitutional restrictions. Some expressed concerns early on in this administration with the president's expanded use of so-called czars, individuals accountable only to the White House, while performing functions that one could argue could and should and in the past have been performed by Senate-confirmed cabinet-level personnel. In the area of religious liberty, you had an unprecedented and fairly radical position taken by the administration in the Hosanna Tabor case that was rejected unanimously, 9-0, by the Supreme Court. Also under the category of religious liberty, you've got a contraception and abortifacient mandate that failed to take into account the conscientious objections of religious institutions, reflecting, I think, a somewhat callous disregard for religious liberty. Then you had the president taking military action in Libya without a declaration of war, without any kind of congressional authorization. Many found that constitutionally problematic. The president's signature legislative achievement, the Affordable Care Act, contains an individual mandate that many consider constitutionally problematic, and that, of course, is before the Supreme Court right now. Then there's one issue that I find extraordinarily troubling, but that hasn't gotten as much attention, which is the president's use of the recess appointment power. Now, every president has made recess appointments, to my knowledge, but this president did something different. He did something that no other president has ever done, to my knowledge, which is that on January 4th of this year, he made recess appointments at a time when the Senate did not consider itself to be in recess, at a time that the Senate, according to its own rules and operating procedures, had been adjourned for a period of time less than 72 hours. This is a concern to me, and the concern is compounded by the fact that in the 23-page single-space memorandum authored by your Office of Legal Counsel, your department seemed to be adopting a rationale that would in effect say that the president may decide when the president deems the Senate to be in recess, regardless of what the Senate's own rules say. So I want to ask you, in light of this position, are you concerned that in the future, appointments historically requiring the advice and consent of the Senate may be made simply unilaterally by presidents of either party without the advice and consent of the Senate?
No, I don't think so. I mean, if you look at that OLC opinion, I think that the rationale, the analysis that they did, I think is constitutionally sound. These pro forma sessions that were put in place where somebody would gavel the Senate for, I don't know, a minute, a couple minutes, whatever it was, were seen by the OLC opinion as not keeping the Senate in session, and it seems
even though we enacted substantive legislation on December 23rd, 2011, just a couple weeks before these recess appointments were made, that was a pro forma session, was it not?
Well, they look at the period from January 3rd to January 23rd and made the determination that there was a 20-day gap there, and within that 20 days, there was an ability for the president to make those recess appointments.
No, wait a minute. But the recess appointments were made on January 4th, only 24 hours or so after the Senate had been in recess. So was this an act of clairvoyance that just predicted how long the president thought the Senate would be in what he considered to be a recess?
I mean, I may have my dates wrong, but what I think the OLC opinion says, and it can speak for itself, is that the time period in which the necessary time period did exist for a recess to be said to have occurred, and the president could have acted constitutionally.
Okay. The president commented not too long ago that he believed that it would be an unprecedented, extraordinary step of overturning a law that was passed by a strong majority of a democratically elected Congress if, in fact, the Supreme Court invalidates the Affordable Care Act's individual mandate or perhaps the law as a whole. In that same statement, he also bemoaned the concept that an unelected group of people would somehow overturn a duly constituted and passed law. Does this reflect a change in this administration's position with regard to Marbury versus Madison that other administrations have not taken?
Well, you might remember that I was given a homework assignment by a federal judge. I had to write a 3-page paper, a 5-page paper, a 3-page paper, I guess it was, single space.
Did you get a good grade on that?
I haven't gotten the grade yet, but I did answer the question. It was the one that you put, which essentially said that this administration understands, the president's a presidential, he's a constitutional lawyer, understands that Marbury versus Madison is still good law. And I explained in that 3-page, single-space letter that this administration still believes that Marbury is good law.
Now, Professor Lawrence Tribe, who I believe has been a friend of this administration and a close ally of this president, commented that presidents should generally refrain from commenting on pending cases during the process of judicial deliberation, adding that even if such comments won't affect the justices a bit, they can contribute to an atmosphere of public cynicism that I know this president laments. Do you agree with that statement?
Well, I mean, I think that, you know, the Supreme Court and the justices are strong-willed people, and they don't have to live in a hothouse environment. There is the need. I mean, even while these matters are being considered by the court, the fact that we have robust conversation amongst ourselves, even those of us who are in official positions, I think is fine. You know, there is some deference. There are certain you should only go so far with regard to your comments. I frequently will myself say, comment about something and say, but this is a matter before the courts, and I really should not go any further than that. So I think some degree of having some idea of where you draw the line, I think is appropriate. But to say we shouldn't discuss anything that is before the Supreme Court or the courts generally, I think maybe goes a little far.
Absolutely. I would agree wholeheartedly with that. I'm certainly not suggesting in any way, shape, or form that the president ought to say nothing, but I think there is a difference between saying nothing and suggesting that it would somehow be appropriate simply because a law was passed by a democratically elected Congress and a duly constituted quorum at that, that the court is somehow powerless to invalidate that, even if it transgresses certain constitutional boundaries. But alas, I see my time has expired, and I thank you for joining us.
Okay, thank you.
Thank you, Chairman.